Hello everyone, I'm Dr. Mangal Singh Bisain, Associate Professor, Department of Law, School of Legal Studies, Central University of Kashmir. I welcome you all to this session on one of the most significant piece of legislation meant for women's right in India. And the title of the legislation, as you can see, is the Protection of Women from Domestic Violence Act 2005, sometimes also referred to as Domestic Violence Act or DV Act. Right. So, when we talk about domestic violence is a serious concern across all segments of society. It not only affects a woman's physical well-being, but also her emotional, psychological, and economic state. The enactment of DV Act in 2005 marked a very transformative moment, bringing a civil remedy to the victims alongside existing criminal provisions under the Indian Penal Code. Now, the Indian Penal Code is referred to as Bharatiya Nyaya Sanhita, right? We'll talk about Bharatiya Nyaya Sanhita or Indian Penal Code in the next slide. Now, this session today In this session, we will explore the concept of domestic violence in depth. That is, what is the historical evolution of the concept of domestic violence, some of the important definitions relating to this, then some legal provisions given under the statute, some judicial interpretations, the judicial case laws, landmark cases relating to the domestic violence in India, and few other points that we are going to discuss today. Okay, so with this, let's start with our presentation. So let's start with the introduction and the historical perspective relating to domestic violence in India. Now, before the enactment of the Protection of Women from Domestic Violence Act of 2005, the preliminary safeguard for women facing various types of abuses, violences within their matrimonial home was given under Section 498A of the Indian Penal Code. Right? Now, as I said, the Indian Penal Code is now replaced with Bharatiya Nyaya Sanhita, right? Also called as BNS, right? And the section that is 498A has now been replaced with section 85 and 86 of BNS, right? But for the understanding purpose, we will continue with section 498A. Now, this section 498A, criminalized cruelty by husband or his relatives, particularly in context to dowry harassment. It recognized both physical as well as mental cruelty, and it considered these actions as criminal acts and provided punishment up to 3 years and fine. However, there was a significant limitation to this legal provision, to section 498A. The first limitation was it was purely criminal in nature, meaning it involved the police and criminal courts, which many of the victims of domestic violence, especially the women, right? The victims were hesitant to approach, right? Approach the police officials, neither the police officials nor the court of law. The second important limitation was it did not offer civil remedies like right to reside in the shared household, protection orders, or financial compensation, monetary benefits. The third limitation, which was faced by Section 498A, was the focus was basically on punishing the offender rather than protecting the victim of crime, that is women, who has faced domestic violence. So, as a result, many women found themselves homeless, vulnerable, and economically dependent even after filing criminal cases. Now, recognizing these limitations, women's rights organizations and legal reformers began demanding a comprehensive legal framework that would provide civil remedies such as, let's say, right to live safely in one's home, protection from further abuse, mm, financial support, child custody, shelter, and many more such remedies. The need for a protective law, and not just a punitive one, was definitely there. A law that would prevent violence and not just react to it. This was a shift in understanding the concept of domestic violence. There was a paradigm shift from viewing domestic violence merely as a crime to seeing it as a violation of fundamental human rights, which required a more holistic legal and social response. Therefore, in 1990s, there was this 1990s is considered as a very crucial decade for gender justice, not only in India but throughout the world. At the international level, India had ratified the Convention on Elimination of All Forms of Discrimination Against Women. This is the title of the convention. I'll repeat: Convention on Elimination of All Forms of Discrimination Against Women. India had ratified this convention in 1993. Under this convention, India now had a burden to protect women from domestic violence. The UN declarations and global conferences also played a very important role. The UN declaration or the global conferences like the Beijing Platform of Action of 1995. This this conference highlighted domestic violence as a major public health and human rights issue. If we talk about within the nation, domestically, women's movement in India were gaining strength. They constantly raised awareness about the silence around domestic abuse, especially psychological and economic. These abuses were not even recognized legally at that time. Now, this global and national movement set a stage for a proper legal reform in the area of domestic violence. And in response to this growing demand, the Ministry of Women and Child Development began working on the dedicated law to address the issue of domestic violence. A key player in the process was Lawyers Collective Women's Rights Initiative. This was led by prominent advocates and feminists like Indira Jaising, a popular name in the field of women's rights. Indira Jaising. Their draft bill was based on extensive research, different case studies, consultation with the women's group, the discussion with the victims of the crime of domestic violence across the country. Now, this draft, which was prepared by this organization, recognized multiple forms of abuse. It not only recognized physical abuse, which was already in existence, but it also recognized emotional, verbal, sexual, and economic abuse. The draft also suggested civil reliefs through simple and accessible legal process. Not too complicated, but simple and accessible legal process. This draft made sure that the law applied to all women in domestic relationships, not just wives, but wives, mothers, daughter, sister, and even women in live-in relationships. Right. After much deliberation, the present statute of the Protection of Women from Domestic Violence Act was passed by the Parliament in 2005, and this statute came into force on October 26, 2006. This statute, when it came into operation, was hailed as one of the most progressive and comprehensive domestic violence laws in the world, right? Shifting the focus from punishment to protection, to dignity, and to support of a victim of domestic violence. Now, if we are going to talk about this statute now. So, the Act comprises of 37 sections, which is divided into five different chapters. Right. Now let's talk about some key definitions given under the statute. There are different definitions which are given under section 2, but we are taking a few of them, not all of them. So first definition which is given under section 2A is of aggrieved person. So who is an aggrieved person? So in simple words, I'll not go with the technical definitions. I'll summarize those definitions. I'll simplify those definitions and present before you. So section 2A talks about aggrieved person. Now, who is an aggrieved person? Any woman who is or has been in domestic relationship with the respondent and who alleges to have faced domestic violence is called as an aggrieved person. I'll repeat the definition. Any woman who is or has been in a domestic relationship, living together with someone else, has been in a domestic relationship with the respondent. The respondent means the person who has allegedly committed the act of domestic violence. So, living with the respondent and who has and such woman is alleging that she has faced domestic violence is called as aggrieved person. In simple words, aggrieved person is a victim of domestic violence. The second definition given under section 2Q is of respondent. Now, who is the respondent? Any adult male member who is or has been in domestic relationship with the aggrieved person is called as a respondent, right? Now, remember one thing, this act has drastically gone, this act has gone a drastic reformation with the passage of time, right? There are different statutes, there are different case laws which has expanded the scope of the existing provisions of the statute. So as of now, we are discussing the provisions as it is. The reformations we'll discuss later on. So, respondent, any adult male person who is or has been in a domestic relationship with the aggrieved person is called as a respondent, against whom a victim has filed a case. Now, here it is important to note that post 2016 judgment in Hirlal versus Harsora, HIRAL, Hiral P, Harsora, HARSORA. ठीक है? In this judgment, now even female members can be the respondents, right? So as I said, it is not only the male members. The Act has statute has undergone drastic change with different judicial precedents. So at the very initial level, only male members were presumed to be committing domestic violence, but now with a judicial precedent, even female members within the family, like the in-laws or the relatives, can be considered as the respondents in a domestic violence case. Okay. The next definition is of domestic relationship given under section 2F. Now, what is domestic relationship? Relationship by marriage, by way of consent, by way of adoption, by or family members living together in a joint family is considered to be domestic relationship, right? So where a group of people are living either through blood relationships or relationships formed out of customs or relationship formed out of consent, right? In or the relationships formed out of contract. These relationships are considered as domestic relationships under section 2F. Okay. Then comes the next definition, that is shared household, which is given under section 2S of the statute. Shared household means the house where the aggrieved person lives or has lived. Aggrieved person lives or has lived with the respondent and or with his in-laws. That is considered as shared household. Okay, so these are some of the important definitions that we'll be referring in the upcoming discussions. Right. Now, let's talk about some important provisions given under the DV Act. Section 3 defines domestic violence. Section 4 allows anyone to report domestic violence. Section 9 talks about protection officers. Section 12 application to magistrate, and section 17 to 12 outlines the reliefs. Right? Now let's have a detailed discussion of these sections because these sections are important when it comes to DV Act. Let's talk about these important provisions. Okay, section 3. Now, section 3 defines domestic violence. Now, what is domestic violence? One of the most one of the most powerful features of DV Act is its broad and inclusive definition of domestic violence. This elaborate definition is included under section 3 of the statute. This definition moves beyond the narrow understanding of domestic violence, that is physical harm. That was a very narrow understanding about domestic violence. Now, according to the Act, according to section 3 of the statute, domestic violence now includes first, physical abuse, that is acts that cause injury, bodily pain, or endangers life or health of a person is considered as physical abuse. Second, sexual abuse, any conduct of sexual nature that degrades, humiliates, or violates the dignity of a woman is considered as sexual abuse. Third one is verbal and emotional abuse, like verbal or emotional abuses like insulting, humiliating, calling names, uh, passing repeated threats, or some kind of a mental torture, right? All these types of actions comes under the category of verbal or emotional abuse. Then there is economic abuse, that is not allowing a woman uh, access to money within the family, or resources or property within the family. This also includes economic abuse, also includes restricting a woman from working or forcing her to hand over her hard earned money. This comes under the category of economic abuse. So As you can see, Section 3 recognizes four types of abuse: physical abuse, sexual abuse, verbal, verbal and emotional abuse, and fourth one is economic abuse. Right. This multidimensional understanding now recognizes that violence is not always visible. Emotional neglect, verbal attacks, financial control can just be as damaging as physical assault upon a woman. This is something that is taken into consideration by Section 3 of the Act. Now, if we talk about Section 4 and 5 of the statute, Section 4 makes it very clear that any person, not just a victim, but any person now can report an incident of domestic violence. Now, who can be included within the definition of any person? Any person means either the victim herself, that is the most primary person to report crime, apart from the victim of crime, apart from the aggrieved person, the parents of the aggrieved person, the neighbors of the aggrieved person, neighbors of that house, relatives, social workers, etc. These people are now authorized to take action to report the incidences of domestic violence. If such other people suspect that such kind of action, such kind of act is happening within a family. Section 5 outlines the duties of police officers. Not just police officers, but police officers, protection officers, service providers, as well as the magistrate. Now, these people, depending upon their role and their powers and duties, these people must inform the aggrieved woman of her rights under the statute, give guidance to her, guide her to access services such as, let's say, legal aid or shelter homes or let's say medical treatment if she's injured, right? Also help her domestic incident report, which is also called as DIR, domestic incident report, and approach to the magistrate for further course of action. Now, this provision, Section 4 and Section 5, establishes that responding to domestic violence is a collective responsibility, not just the burden of the victim herself. Now, Section 9 talks about role of protection officer. A key role in the implementation of the Act is of that of protection officer. Protection officer who is appointed by the government under Section 9 of the statute. The primary responsibility of this protection officer includes assisting the victim in filing the application before the magistrate and preparing the domestic incident report DIR, ensuring service of notices and protection orders, and also coordinating with medical facilities, legal aid centers, and shelter homes to give assistance to the victim of domestic violence. Now, these officers, they act as a bridge, kind of a bridge between the victim of DV, domestic violence, and the legal system, the legal remedies which are available to such victim. Ideally, what I have seen is that ideally in every district, uh, there are protection officers, and it is also suggested that there should be trained and accessible protection officers wherever such appointments are not made. In practice, many districts are can also be seen that they are under-equipped uh, in making these arrangements and making implementation. This makes the implementation of the DV Act quite a big challenge for the legal machinery. Now, Section 12 talks about application to the magistrate. Now, Section 12 is the one section which enables an aggrieved party, aggrieved person, or someone on her behalf, right, any other person, to file an application before the magistrate for seeking various reliefs which are given under the statute. As soon as the section also suggests the procedure which is required to be followed by the magistrate. A magistrate must take action within 3 days of receiving of the application. This is important. Right? This is kind of a duty that has been imposed upon the magistrate that he should take action within 3 days as soon as he receives the application of DV. The hearing before the magistrate is summary in nature. It means that the hearing takes place very fast and is non-intimidating in nature. Reliefs in such applications can be granted after hearing the victim and the respondent. This is important. Now, this section, section 12, ensures that justice is accessible and time sensitive, unlike the other civil suits, which many a times what we see takes years to process. Section 17 to section 12 talks about reliefs which are available under this statute. The reliefs which are given under section 17 to section 12 primarily provides civil remedies that directly address the needs of the survivor. Now let's have a quick look at these sections, section 17 to section 22. Section 17 talks about right to reside. A woman shall have a right to reside in the shared household, regardless of ownership or legal title. She cannot be evicted from such residence by force. That is given under section 17. Section 18 talks about probation order. A magistrate under section 18 can restrain the respondent from committing further acts of violence, contacting the women, or entering the place of work, school, or residence by the respondent. The magistrate can issue kind of a stay order, kind of a stay away order, right, restraining the respondent from carrying out such activities, right, just in order to protect the women and prohibit the respondent from committing any further types of violences. So he is prohibited from entering at such places where the women generally resides or the women generally is found, place of work, school, residence, college, whatever. Section 19 talks about residence order. The court may order the respondent to remove herself from the shared household, and the court, after removing such respondent, such aggrieved person, such respondent, may also provide alternate accommodation to that such person. The court may also issue an order to the respondent not to alienate, not to sell off or dispose of such property. Such residence-related orders can be issued under Section 19. Section 20 talks about monetary relief. Monetary relief may include loss of earnings, medical expenses, maintenance, right? Maintenance for herself as well as for her children, and at the same time compensation for any destroyed property destroyed by the respondent in a fist of rage or whatever, right? All these things can be claimed before the court of law and can be granted by the magistrate. Now, section 21 talks about custody order. Temporary custody of children can be granted to a woman with or without visitation rights to the respondent. Means the respondent can be prohibited from visiting his own children if such an order has been passed by the court of law. Generally, the court allows the respondent to visit his children. The court will grant the custody to the woman and allow the respondent to visit his children, let's say once in a week or once or twice in a month. Right. But these visitation rights can also be denied to the respondent depending upon facts and circumstances of the case. Now, Section 22 talks about compensation order. The magistrate can direct the respondent to pay compensation. Compensation for, let's say, physical injury or mental torture or emotional distress caused to domestic violence victim. Now, if you look at these provisions are primarily designed not just to punish the respondent, right? They have some element of punishment, but the primary object of these punishments is to empower, to make sure that the woman is safe, supported, and given a chance to rebuild her own life, to live with dignity. Okay, so uh, let's talk a little bit more about the reliefs which are provided under the statute. Now, as we discussed, Section 18 talks about protection order, Section 19 talks about residence order, Section 20 monetary relief, Section 21 custody orders, and Section 22 compensation orders. Right. So these are the different types of orders which can be issued by the court of law. Now, remember one thing: the DV Act of 2005 is not just a law against abuse. It's a whole framework for supporting the survivors of domestic violence. It offers a range of civil reliefs that can be claimed by a woman, claimed from the magistrate by the women. These are meant to ensure that such woman is safe, she lives with dignity, and her well-being is protected. Now let's talk about these five major reliefs provided under different sections. So the first one is protection order given under section 18 of the statute. A protection order is one of the most crucial safeguard against given under the act. Once a magistrate in a case is satisfied that domestic violence has occurred, such magistrate can prohibit the respondent, that is the abusive person, that is the wrongdoer, from doing acts such as committing an act of domestic violence again, attempting to attempting to communicate with the women either in person, physically in person, or by way of some electronic medium like telephone or email or WhatsApp call, or through some third person. Such communication can be prohibited. Again, the respondent can also be prohibited from visiting the place of work of a woman, or if she is a student, then her school or the residence of such woman. Right? The respondent under section 18 under the protection orders can also be prohibited from alienating any assets or causing harm to her relatives. And at the same time, the section is not a closed one, it's an open ended section, which at the end says that the respondent can be prohibited from committing any other specific act as the court may deem fit. So it's an open-ended section, right? There is lot of discretion with the court to prohibit the respondent from doing things which are harmful to the aggrieved person to the case. Now, these types of orders basically act as a legal shield designed to immediately stop the cycle of abuse, the cycle of domestic violence. Now, Section 19 talks about residence order. This Section 19, recognizes a woman's right to live in her shared household, a concept that was not clearly protected before this statute came into existence. Now, under residency order, the magistrate can prevent the respondent from evicting or excluding the woman from her house, right? In a little bit of rough language, throwing a woman out of her house, out of his house, right? So, such action can be prevented. The court can also direct the respondent to remove himself from the shared household if necessary for the safety of a woman. Right? Not only the court will allow the woman to live in the house, but the court can also direct the respondent to leave the house and live somewhere else. The court can also restrain the respondent from entering certain areas of the house. If the house is a bigger premises, right? Then certain areas of the house, the respondent can be prohibited from entering certain areas of the house. The court can also order alternative accommodation or, let's say, rental support if staying in the same house for the is unsafe for the respondent as well as the victim of domestic violence. It's important to note that ownership doesn't matter. In such type of orders, ownership doesn't matter. Even if the house is in the husband's or in in-laws name, a woman has a legal right to reside there. If it was her as if it was her matrimonial home, or if she lived there in a domestic relationship, she has the right to live in such house, and the other people can be excluded, can be removed from such house. This is the power of Section 19 or the DV Act. Section 20 talks about monetary relief. This section ensures that the survivors don't suffer financially. They do not have financial insecurity in addition to what they have suffered previously, all the physical and emotional trauma that they have undergone. The court in under Section 20 can direct the respondent to pay monetary relief. Monetary reliefs such as, let's say, medical expenses resulting from the acts of violence, or let's say loss of earnings, especially when the woman is prevented from working, the right of maintenance for the woman and her children, and damage to property. Damage to property, for example, if her belongings were destroyed or damaged during such abuse. Now, this is separate from maintenance. Right? Try to remember this. Maintenance is a different provision and Section 20 is a different one. This is different from maintenance, which is given under Section 125 of CRPC. This is a civil relief specifically aimed at compensation and rehabilitation. The made payment may be made either in lump sum, that is typically known as alimony under maintenance law. So the payment can be made in lump sum or as monthly installments as the court sees fit. Now, Section 21 talks about custody orders. Domestic violence often affects children just as deeply as it affects the mother. Section 21 allows the magistrate to grant temporary custody of children to the women. Right? Temporary custody of children to the women. Temporary, that is till the case is finally decided. Now, this order is interim in nature, means it provide immediate safety and stability to the family. The court in such cases may allow or restrict visitation rights, right to visit of the respondent, depending on what is in the child's best interest. The interest of the child is of paramount importance under almost all the laws relating to children, and that is also taken into consideration under DV Act. A woman need not file a separate case in a family court, but this order can be passed as part of domestic violence proceeding itself. Right? No one need to go for a separate legal compliances. Now this helps to ensure that the children are not used as tools for tools of manipulation, and that their welfare is of utmost importance. They are to be dealt on priority basis. Section 22, that is compensation order. Now this provision recognizes that violence leaves certain scars beyond the visible injuries. Right? This section recognizes that violence leaves scars which are beyond visible injuries. Under Section 22, therefore, the magistrate can direct the respondent to pay compensation or damages. Compensation or damages for, let's say, mental agony or emotional distress or physical trauma or any other kind of injury caused by the acts of domestic violence. Now, this relief is significant because it acknowledges the emotional cost of abuse, which generally in which previously used to go unnoticed. Now, as far as the amount of compensation is concerned, the amount is decided by the court of law based upon the circumstances of each case, right? Including the duration and severity of abuse that has taken place. Now, if you look at these reliefs are not just legal rights, they are more of life-saving lifelines. They help ensure that the survivors of domestic violence are not left without options. Therefore, the DV Act offers a non-criminal, fast, and survivor-centered approach where a woman doesn't have to wait years in the court or face the intimidation of police procedure, right? To get appropriate help, proper help. With the help of a protection officer, she can seek immediate orders to protect her home, her children, and her mental well-being, including her property as well as her property, right? So this is the importance of all these orders. Now let's talk about the procedure and implementation. This is something that we have some part of it we have already discussed, but let's go into a little bit more detail. Now, the DV Act is designed to be victim centric, time sensitive, and easily accessible. This ensures that the survivor doesn't have to wait endlessly or navigate complex legal pathways to seek help from legal machinery. Now, let's go over the key procedural safeguards and the support ecosystem built into this act. First point, magistrate must act within 3 days. Now, according to the Act itself, once an application is filed under Section 12, the magistrate is required to begin proceedings within 3 days. Now, this legal provision ensures that speedy hearing of domestic violence complaints takes place, immediate action in cases involving safety and shelter are uh, taken. This provision shifts away from the traditional delay in civil litigations. Right? That is the importance of the time period, time limit. The urgency in Section 12 reflects the nature of domestic violence, and it is often ongoing, and any delay can lead to further action. That is the reason why there is a time period, which is time limit, which is required to be followed by the magistrates. The final order is also required to be passed within 60 days. The Act mandates uh, that all relief orders, just a minute. Okay. The Act mandates that all the relief orders, uh, let's say whether protection orders or residence or monetary or custody or compensation, all the orders that we discussed in the previous slides, all these orders must be passed within 60 days from the date of first hearing itself. Now, again, this timeline is also crucial because victims of violence need timely relief, not lengthy trials. That is the whole purpose of the DV Act. It is important because it ensures accountability in the judicial system. Survivors are empowered to seek justice without being trapped in the prolonged legal battle. Now, this goal is to make the goal behind Section 12 and 28 is to make the legal process swift, simple, and the survivor friendly, aggrieved party friendly. Now, the role of service providers and NGOs. One of the most progressive features of the Act is it recognizes service providers under Section 10 of the statute. Now, who are service providers? An NGO, non-governmental organization, a shelter home, or short stay home, or a counseling centers, or a legal aid clinic. All these are included within the definition or within the preview of service providers under Section 10 of the statute. The statute also provides for their duties. So it is the duty of the service providers to assist the victim of domestic violence in filing domestic incident report, DIR, as we discussed previously. They are required to provide safe shelter and emotional support, help the victim get medical care, legal aid, financial support, and sometimes even represent the victim before the court of law, in the court of law. So basically, service providers act as the first line of support, especially for women who may not be aware of their rights or how to assess these rights. Right? There may be uh, either ignorance of law, or there may be lack of knowledge of the legal process. Then comes free legal aid and medical assistance. The DV Act mandates that every woman who approaches the system under DV Act should have access to legal aid. Under the Legal Aid Service Authorities Act, free legal aid must be provided to the victim. That the statute is already there. Right? Protection officers and service providers must inform the women of their rights. Medical assistance, medical facilities are required to treat women reporting domestic violence without delay or without any kind of discrimination. Medical reports. In cases of domestic violence, medical reports can serve as a crucial evidence in securing protection or compensation orders. Right? They have strong evidentiary value in the court of law. Therefore, immediate medical uh, attention is required to be given to the victims of domestic violence. These provisions provide help. These provisions help reduce the economic and psychological burdens on the victim without making the process more inclusive, with making the process more inclusive and human in nature. Right. Now let's talk about appeal under section 29. Finally, if either party, either the aggrieved party or the respondent, right, the women or her in-laws, as the case may be, is dissatisfied with the order of the magistrate, they can file an appeal under section 29. But the appeal must be filed before the sessions court, and secondly, it must be filed within 30 days. 30 days from the date of magistrate's order. Now this ensures that legal system remains fair, offering recourse to grievance or error, while also being protective of the survivor's rights. Right. So basically, these procedural safeguards that we discussed in this slide and the support mechanisms ensure that the DV Act is not just a symbolic law, but a functional and responsive legal system. It reflects a shift towards a victim empowerment and not just victim protection. By bringing together judicial efficiency, community support, and institutional accountability, the DV Act, aims to create a safe and just space for women to, let's say, speak out or seek help and thereby rebuild their lives. Okay, now let's talk about some important legal judgments relating to DV Act. Now, remember, there are many legal judgments. There is a whole bunch of judgments which stands to be landmark in nature and which have brought drastic changes in the implementation of the DV Act in uplifting the rights of the women under different scenarios. Here I have taken a few of them. So the first one is Hiral P. Harsora versus Kusum Narottam Das Harsora. I may be mispronouncing the name, but the title is written in front of you. Now, this is a case of 2016. Now, in this case, the Supreme Court removed the restriction that only adult male members of the family could be respondents under the Act. Now, after this judgment, the judgment of 2016, now even female relatives of the husband or partner can be named as the respondents. This, in a way, has widened the scope of protection and thereby recognized that abuse can also come from women in a domestic settings. Women like, let's say, mother-in-law or sister-in-law or someone like that. So this case of 2016 recognizes women as respondents. The second case, that is Indra Sharma versus V.K.V. Sharma, the case of 2023. In this case, the court held that live-in relationships that are in the nature of marriage, kind of marriages, right, are protected under the Domestic Violence Act. Therefore, a woman in such kind of a live-in relationships can seek protection and relief if they face abuse in such relationships. This is kind of a progressive step, recognizing challenging social norms and offering legal protection beyond the traditional marriage institution. The third case is Krishna Bhattacharya versus Sarthi Chaudhary, the case of 2016. Now, in this case, the court clarified that remedies under DV Act remain available even after divorce. Remedies are available even after divorce. Acts of violence or cruelty that occurred during the marriage can still be addressed post divorce also. Now, this ensures that justice is not denied to the victim of domestic violence just because the marriage has ended. Right? In the last case, the fourth one, that is Satish Chandra Ahuja versus Sneha Ahuja, the case of 2020. This is a landmark verdict in which the Supreme Court confirmed a woman's right to reside in the shared household. Right? Women's right to reside in the shared household regardless of the ownership of the house. Now, the house may be in the name of the in-laws or of the relatives, but if it was her matrimonial home, she cannot be evicted without due process. Now, this ruling strongly reinforces Section 17 of the Act. Now, these judgments as you can see, these judgments have significantly increased the scope of Domestic Violence Act, thereby ensuring that it remains a dynamic and effective tool for protecting women in evolving family structures. Right? Now let's talk about the recent amendments and developments. In short, as I said, there are so many amendments and so many developments that are happening in the field of family law and in the field in the issues such as Domestic Violence Act. But these are some of it I have pointed out. Now, while there have been no major legislative amendment in the DV Act as such, since its enactment, the courts have played a pivotal role, a very important role in shaping and expanding the laws of domestic violence. Now, these are the four areas which I have identified to talk about. Through the Act, initially referred to domestic relationships in a traditional marriage sense, the court have clarified that live-in relationship can be protected under the Act. Right? The case of Indra Sharma versus V.K.V. Sharma. Right? The court, as we discussed this case previously, the court ruled out that a woman in a live-in relationship that is in the nature of marriage is entitled to protection under the statute. Right. This interpretation ensured that the law adapts to modern realities and protect women in non-marital relationships as well. Right. Now, strengthened interpretation and interpretation of shared household. The meaning of the shared household has been subject to many debates. Right. In many cases, courts have now broadened this term to protect women's right to residence. Right. So in Ahuja case that we discussed previously, the Supreme Court held that women has a legal right to reside in a shared household. Increasing sensitivity towards mental and emotional abuse is one recent development that has happened in the field of the DV Act. Right. Initially, as we discussed, initially DV Act primarily focused on the physical abuse. However, recent judicial attitudes show greater recognition to emotional, to psychological, and verbal abuses. Right? Like in one of the cases, the case of Kishore versus State of Maharashtra, the case is of 2018. The case was before Bombay High Court. The court in this case acknowledged that mental cruelty and controlling behavior is a valid ground for seeking relief under the Act. Courts now more consistently uphold non-physical forms of abuses. They are now reflecting a more holistic understanding of violence. Right? Now, the DV Act mandates that the relief be granted within 60 days, but in reality, the delays are common. Right. Even though there is a time limit given in the statute, practically speaking, it takes some time to get the relief from the court of law. Some states have begun exploring dedicated or let's say fast track courts for the domestic violence cases. For example, in Delhi and in Maharashtra, these the governments have introduced pilot projects for quick resolution, although implementation is kind of uneven across India. Now, this shows a growing recognition of the need for timely justice through consistent progress is required in case of domestic violences. So, we can say that while legislative enactments and amendments are are minimal in nature, right? Judicial interpretations, on the other hand, and administrative reforms have greatly expanded the scope and accessibility of the Act. These developments have ensured that the DV Act remains relevant, inclusive, and victim friendly in today's context, right? Now, if we talk about the statistics and impact assessment, statistical data and their impact, to truly understand the impact of uh, DV Act, we need to look at some data and also to some ground realities. Right? Now, according to the National Crime Records Bureau, NCRB, the report by NCRB of 2023, over 30,000 cases were registered under Section 498A of IPC, which deals with cruelty by husbands and in-laws. So basically the domestic violence cases. Right. This is rather a very staggering number, and it reflects only the reported cases. not the unreported cases, but the reported cases. And therefore, the actual instances are believed to be much more higher, right? They may be higher because of underreporting or non-reporting by the victims of domestic violence. Then protection orders underutilized. Despite being the core relief under the DV Act, protection orders are generally seen to be underutilized. They are rarely issued uh, in proportion to the number of cases, to the number of complaints that are received by the magistrate. This may be due to delays in court proceedings, lack of awareness about the available reliefs, or hesitance among the women to involve justice system due to fear of backlash, backlash from the in-laws, backlash from the society. Right. Now, if we talk about the major challenges in implementation, the major challenges which we can talk about here is, in this case, is low awareness, both in rural as well as urban areas. Right? Domestic violence is seen to be happening in both the areas, rural as well as urban. Delay in issuing orders is one major challenge, even after having a timeline of 3 days and 60 days and on. Societal pressure and social stigma is generally seen to prevent a woman from taking the legal action. And finally, inadequate number of shelter homes and lack of rehabilitation services also stands to be a major hurdle in the path of implementation of Domestic Violence Act. Now, these hurdles are often seen to discourage any women from seeking help, even when proper legal protections and judicial precedents exist. Right? To make DV Act truly effective, there must be a stronger coordination among key stakeholders like police to ensure timely response and enforcement, among judiciary to deliver prompt and survivor sensitive orders, between NGOs and service providers to assist with the filing of the complaints, counseling, rehabilitation, and at the same time, community support networks as well to reduce the isolation of the victims of domestic violence. Now, this multi-agency approach, multi-agency coordination is essential to transform the law from, let's say, law books or paper to practice. So, the DV Act has led a solid legal foundation, but data shows uh, that much more is needed to be done. Better awareness, uh, faster relief, then supportive ecosystem, and all these things are crucial in ensuring that every woman who is facing domestic violence is heard, is helped, and is healed. Okay. Now, with this, we come to the end of today's session. Summarizing the session, the DV Act is a progressive law providing civil remedies to the victims. However, its implementation remains a big concern. So, we as a society need more trained protection officers, increased awareness and gender sensitization among the victims among the people living in the society. Stronger victim support system is has become a need of time now. So basically, every domestic woman deserves a life free from violence, and the laws like the Domestic Violence Act are kind of a step towards that vision. With this, I hereby conclude my session on the DV Act, and I thank you for patiently listening to the session today.